In 1991, President George H.W. Bush signed the Telephone Consumer Protection Act, or TCPA, into law in order to crack down on those annoying telemarketing calls that always seem to come around dinner time. 20 years later, that same law still governs all sorts of business to consumer communications, but it doesn't just regulate old school landlines. It regulates emails, faxes, texts, social media messages, and more now falling under its purview, even though some of those didn't exist back in 1991. Instead of putting an end to annoying phone calls, the TCPA has become a cottage industry for plaintiffs' lawyers. They've been able to turn thousands of lawsuits into paydays, and in some cases by trapping businesses into calling old numbers or suing in cases of clear mistakes. I'm Matt Webb of the U.S. Chamber Institute for Legal Reform, and in this episode of Cause for Action, we're going to take a deep dive into the law, a current TCPA case before the U.S. Supreme Court, potential legislative reactions, and how the new administration may oversee this arena. And I'm joined now by Mark Brennan from Hogan Lovells and Megan Brown from Wiley Rein, two of the foremost experts on the TCPA. Good afternoon to both of you. And Megan, I hope you're doing well. And Mark, hope you're doing well as also. And wanted to kind of start our conversation. So, Mark, let's kind of start with you. I mean, and actually start at the beginning. So if you could kind of tell our audience kind of what the TCPA is, why it was created, and why someone listening to this episode should actually care about the act.
Matt, thank you. Happy to do so. And thank you to you. Thank you to everyone who's listening. And thank you to ILR for having us. Appreciate the opportunity. And always good to connect and talk about these issues. Well, let me start with why people should care. The TCPA has a very personal, practical impact on whether and how you receive time-sensitive communications, healthcare notifications, data breach and identity theft alerts, deadline reminders, and more. It's the TCPA that today creates some of the largest challenges for companies looking to engage with consumers in these types of non-marketing communications. And frankly, it has even more of an impact for consumers that may live in rural areas or who may not have ready access to broadband. And it's also important for those who care about jobs, American call center jobs in particular. There are a lot of call center jobs that intersect with some of the legal issues we'll be talking about today. And then finally, from a legal perspective, it matters because it's become one of the most sued under federal consumer protection laws, with class action liability and board level concerns being highlighted every day. As for what it is and the background on why it was created. So look, the TCPA was passed in 1991, and it regulates how consumers and businesses can connect with one another across a number of platforms. Just for context, in 1991, that's around the same time that the internet was finally made available for broader commercial use. And the number of connected computers that were logged in to the internet was about 1 million. It's also around the time that web browsers were introduced and Microsoft released MS-DOS 5.0. So a number of things have changed. The TCPA, however, remains substantially intact. It is a law that, as you mentioned, regulates how companies can connect on telephone calls, emails, faxes, text messages. Now, there's some pieces of that were in the legislation, other things that we've seen adopted along the way, but that's the core here.
Great. So, Megan, I mean, we hear a lot about problems with the TCPA, and it's an outdated statute. I mean, it's going back to 91. As both Mark and I mentioned at the outset. And I mean, if I'm remembering correctly, I mean, I think that wasn't too far beyond when texting really got started. So, I mean, it is a very old statute. How did it actually become such a vehicle for abusive litigation, and what are some of the problems with it?
Well, I mean, I think the key problem that has created the cottage industry that Mark referred to is the statutory damages. The statute has a provision in it that says you get a plaintiff potentially can get $500 per violation. And if you think about the platforms that facilitate communications these days, those numbers can rack up very quickly. And so it's really, to me, the statutory penalty piece of the statute is one of its worst features. And I think, Congress had in mind they wanted to discourage some of the bad practices. And when we say bad practices, we mean like, the abusive calls that were coming repeatedly from debt collectors, things that are not sort of the mundane text message kind of things that are often the basis of suit nowadays. So it's this multiplier effect when you have a class action as the vehicle, and this statutory damage. The statutory damages can get up to $1,500 for sort of repeat players here. But one study, and ILR has been doing great work, sort of shining a light on these litigation abuses. One study has found that the average TCPA plaintiff was awarded over $4 million, and the average lawyer representing that plaintiff got around $2.5 million. And these large paydays have encouraged a lot of lawyers and a lot of plaintiffs to look at the TCPA as, sort of a jackpot justice vehicle. And not surprisingly then, over a period of time, I think between, say, 2010 and 2016, the number of TCPA lawsuits increased by 1,200%. So you saw this sort of rush to the courthouse when you realize that it's not too difficult to draft a complaint. And some of the defenses relied on uncertain areas of the law where maybe the FCC, the Federal Communications Commission, hadn't spoken with enough clarity. And so we saw lawsuits of all varieties, not against the real bad guys, right? The offshore entities who are impersonating cruise ship operators and doing abusive, fraudulent activity. We see suits against the LA Lakers, Jersey Mike's sub shop, right? Over things that consumers have shown time and again that they kind of like, loyalty programs, right? That was what happened in the Jersey Mike sub shop. A gentleman had joined the loyalty program to get a free sandwich after a certain time. He got a text and he sued the company. And eventually his lawsuit was dismissed because he couldn't remember if he gave them his phone number. The cannabis industry, marijuana stores are now being hit with TCPA suits over the past couple of years. So there's opportunism here. And it's unfortunate because these suits can be very difficult to defend, and you might not be able to sort of resolve the issue because of the definitional question that Mark and I are going to talk about. But these abuses are sort of legendary now. Plaintiffs have even gone so far as to, collect cell phones and keep them in a box under their desk so they can rack up claims when they get erroneous calls. So it's frustrating to watch. It's a giant payday. And I think it all comes back to some of the definitional elements, but really it's that statutory penalty that makes it so attractive.
Mark, it sounds like, based on what Megan was saying, it almost sounds like there's a cottage industry out there engaging this type of litigation. You want to add on anything with following what Megan said?
Yeah, Megan described it exactly right. The statutory damages are just too appetizing. I think from the plaintiff's bar perspective, it's kind of like having a series of scratch-off lottery tickets. At some point, you're going to hit one that may win big, or at least that's the theory. Unfortunately, those efforts continue to put a lot of cost and burden on good faith, compliance-minded American businesses. And that's been a challenge. And ILR has been very active in this space in trying to fight against these abuses, but they continue to occur. And frankly, it's a large number of these TCPA cases where, you'll read a headline and you'll think, oh, something must have gone wrong there. Well, maybe there were a lot of calls because nobody answered the calls, and the caller wasn't even trying to reach that number. Maybe somebody didn't give their updated contact information, or somebody moved and the caller was trying to learn about a data breach, but then all of a sudden there's a lawsuit. I just think you start to see a large number of these cases more on the abuse side rather than a credible claim.
So, just to be clear, we're not talking about the true scam or scam type calls where folks are going after legitimate bad actors. It sounds like the issue is that, as I said, this is a kind of a cottage industry that is going after legitimate businesses doing very legitimate wanted types of phone calls or other types of communication with their customers. And it's like I said, it's a payday sort of deal for the trial lawyers who are bringing the cases. I mean, have there really been any real efforts at trying to get reform in this space?
Well, you don't need the TCPA to go after the bad actors, right? Fraud is fraud. Fraud is illegal. You don't need the TCPA for that. And that's where I think there's become this bit of confusion out there when people talk about the TCPA, people talk about robocalls, because when we're, the efforts to go after the scammers and the fraudsters, there are a lot of different ways to do that. And statutory damages that punish good faith callers is not the way to do it. As far as reform, ILR has made a strong effort over the years to seek reasonable improvements to the TCPA and the surrounding legal frameworks. But from us, it really depends on your perspective, because when you were asking about serious efforts at reform, to be sure, there have been numerous attempts to protect consumers against all kinds of harm in the communications space, and plenty of other efforts to rein in the scammers and fraudsters and other bad actors. And there have been some amendments proposed to the TCPA over the years, and some of them got through. But in terms of a serious effort across stakeholders to really identify where the gaps are in the statute, why some of the good faith efforts to address consumer needs are just sort of being taken over by the plaintiff's bar in this space. No, I don't think we've seen engagement by consumer groups. I don't think we've seen engagement by the plaintiff's bar. I think there's been the steady drumbeat that any call is a bad call. And it's very difficult when, we're sitting here now a year into the global pandemic, and there are so many calls that need to be made regarding health issues, supply, delivery notifications. And you just see this trend where, if somebody is trying to use any type of efficient technology to reach large numbers of consumers, they're immediately vilified, and that's just not the right approach. So no, I think there's still a lot of opportunity and a real need to try to bring stakeholders together and get some reasonable outcomes here that can protect consumers and make sure that they get the calls they need and want.
And let's just be clear, Matt, just to tag on to that just real briefly, and Mark does a lot of this work just like we do. The FCC, Federal Communications Commission, has several, dozens of proceedings ongoing right now to deal with the real problem of illegal and unwanted robocalls made by the true bad actors. There's technical solutions, there's other things. It's almost as if the TCPA is sort of off in it, this litigation under the TCPA is off in its own world, generating litigation, generating damages, awards, and fees that have nothing to do with the hard work that folks have been doing to deal with the real problem of illegal robocalling. So I just wanted to make that point. It's not as if people are asleep at the switch here. The FCC's the staff over there have been churning on these activities.
Well, and also, I guess the way I look at it is that for the plaintiff's bar, the reason they don't go after the real bad actors is because, they're effectively judgment proof. Right. Because, they're offshore, they're engaging in, blatantly potentially criminal or actual criminal activity. So, if it was really truly about protecting consumers, you would think they would be trying to go after the folks that are doing the really bad stuff and not someone who's trying to communicate a fraud alert to customers. And I think a lot of what we've been hearing from ILR's members, as well as the broader chamber membership and elsewhere in the business community, is that companies are genuinely concerned about trying to communicate with their customers on things like fraud alerts, utility alerts, medical appointments. I do wonder what's going to happen in the context of COVID, and whether or not, say, for folks are trying to provide information about vaccine availability or something like that, and whether or not that's going to become an area where people are questioning whether or not they could send a text message or make a phone call to people. And that's not, the law should not be available and used in such a way to limit public health that way. And unfortunately, I think the fear of litigation is really driving a lot of business decisions that are having some real world negative impacts on the average consumer, and it really needs to be addressed.
Yeah.
So, but looking, kind of moving from the legislative and regulatory space, I mean, I know the Supreme Court's looking at a number of issues under the TCPA right now, and there's the Facebook case that's pending before the court. And they heard oral argument back in December. Megan, if you can kind of just give our audience just sort of a brief description of what that case is about, and kind of where we think the court may be going, and what sort of impact that decision may end up having in this whole area of the law.
Sure. Well, I think this will be the third case that the Supreme Court will have had in recent years dealing with the TCPA, which kind of confirms there's a lot of litigation about this statute, because the Supreme Court doesn't take a lot of these cases. And so if you get 3 cracks at some part of the TCPA, I think that alone should signal that there's some things that need attention. In Facebook versus Dogood, which was argued in December, I think a lot of folks are hoping that the court is going to bring some clarity to a key definitional piece of the statute. And your listeners' eyes are going to glaze over if I get too deep, so I'm going to stay very high level here. The statute centers on restricting the use of auto dialers, or automated telephone dialing systems, ATDS, right? And what is at issue in Facebook is Facebook got sued by a guy who got texts and said he shouldn't have gotten these texts. They were security alert, log on attempt alerts. And he said, I shouldn't have gotten these texts. I didn't consent to this. And he sued. Facebook said, whoa, we're not even using an auto dialer here. The statute has several pieces to it, and it was a fight about whether the words in the statute can be read to apply to the technology Facebook was using to send out text messages, and whether a clause in the statute applies to one verb or 2. Does it store or produce with we're using a random or sequential number generator? And so that's what a lot of these lawsuits end up being about, is fighting about what that means. And the FCC has had chances in the past to clarify that doesn't mean everything. But if taken to its most extreme application, it could cover a smartphone that has the capacity to store and produce using a random or sequential number generator. So it has this feeling of the theater of the absurd, but these are the kinds of questions that companies have to litigate. So Facebook said, we didn't use an ATDS, we're good. And the trial court agreed. Then the Ninth Circuit, Court of Appeals out in California, Oregon, and Washington, they disagreed and said, nope, we think this case can go forward. We think looks like Facebook could have been seen as using an auto dialer. Facebook takes that up to the Supreme Court, which now has in front of it this question. They also have some First Amendment issues, but they didn't seem to care so much about that. So this argument was extremely wonky. It was very much like the battle of the grammarians. And I am very eager to hear Mark's take on it. The Supreme Court was very frustrated, I think, with both the statute, its age, the technology, the fear that if they do the right thing in terms of reading the statute, will they open the floodgates to a lot more robocalls? I think that fear is not well founded, but there was a lot going on in this argument. And I think a lot of people are holding their breath, hoping that the Supreme Court kind of calls it the right way, reads the statute as its words require, and kind of respectfully does the job that the FCC hasn't done, or that it kind of messed up in 2015. But my takeaway is there is so much litigation about this that it really is sort of obvious that something needs to be fixed here, and we'll see what the Supreme Court does. I found the argument very interesting to listen to because of the breadth of questioning by the justices and the clear frustration they had that maybe they shouldn't be asked to fix what Congress did so long ago in light of new technology, that they were feeling maybe a little bit pushed into a regulatory kind of role. But I'm curious for what Mark thought of it, because we both listened to it and have our views.
Yeah, it's not every day we get to have a Supreme Court case on TCPA issues, but it's more days than we thought it would be. I honestly, I hope they clarify the auto dialer issue once and for all. This court has a habit of being very cautious about only addressing the bare minimum needed in that particular situation. So for any number of reasons, it could be sent back down without a clear clarification. But I really hope that they settle this, because we've now been waiting for the better part of a decade to get some real clarity on what this means, because it drives so many other requirements. And I think what we learned from the case, the oral arguments, is words matter, right? So as Megan said, there are a variety of ways to look at different framings and the impact, but words matter. And it's for Congress to decide what words to use. The statute, as I mentioned, is, it's from 1991. So with that in mind, you want to be thinking about, probably good time to do an update anyway. But what we've had in the last few years has instead been a mix of different court decisions that conflict with one another, an FCC that's not been able to issue a clear nationwide binding interpretation. And so if you're a company trying to provide consumer services across more than one state, more than one region, you're really in a bind. And I think everybody's losing out here except the plaintiff's bar.
Yeah.
Amen.
And I mean, talking about the tenor of the argument, I think it would have been interesting had Justice Scalia been on the court with his particular view of statutory interpretation. I mean, not to get even more wonky, Megan, but it's that would have been interesting to hear him trying to parse that out. But
well, the plaintiffs, I will say, the plaintiffs boldly, I think, and very interestingly, hired as their lawyer Brian Garner, who wrote a book on statutory interpretation with Justice Scalia. And I think there was this expectation that he would capture the statutory interpretation nerds. But the argument, all the justices seemed very frustrated for their own reasons with both the statutory interpretation arguments and what has to be in the back of their mind, which is the sort of policy reaction that people will have, rightly or wrongly. But it was a very interesting argument for that reason as well.
Yeah, I mean, I was also struck with, and you kind of pointed this out a little bit, of that. And I think even some of the justices were struggling with the fact that if your personal cell phone could potentially, or smartphone could potentially be swept into an automatic telephone dialing system under the statute, based on just a plain text sort of possible plain text reading of it, which is, as you point out, I mean, it's a theater of the absurd that everyone is walking around violating a federal statute and subject to statutory penalties just by using their smartphone, which unfortunately, I agree with you that if you take the plaintiff's arguments to their logical conclusion, it's kind of frightening for where that thing potentially goes. And
as part of the discussions, it didn't seem like there are certain positions that each side was advocating for, and then there are some that are perhaps framed a little more in the middle, and the justices didn't seem to pick up those midway solutions. So it'll be interesting to see where they come out on the votes.
Yeah. When do you think a decision's coming down?
Well, they typically have to do by the end of June. This was argued in December, so I would think we could see one kind of any time, depending on how fractured it is. My fear is we may see many, many opinions about it, which would be terrible for the lower courts and for litigants. So I share Mark's hope. I hope that they do this clearly and definitively and right. But we shall see. But it could be the latest it'll be is end of June, but I think probably this spring sometime.
Yeah. What do you think the odds are that's going to be Justice Barrett writing the court's opinions that she's already written on this?
Oof. I don't like to prognosticate. I don't know.
Okay.
That's for SCOTUS blog to figure out.
Okay. Fair enough. So let's say that the court does issue a ruling that is workable. Is there a will for Congress to modernize the law? I know that's been a perennial discussion within the business community and elsewhere on the Hill. So, do you think they get involved?
I would hope that Congress, if the almost under any outcome of the Supreme Court, given the frustration at oral argument and the age of the statute and just the fundamental mismatch between what problem Congress was solving in 91 and how it's being used, I would hope Congress would get involved. The House had a hearing in 2017 looking at lawsuit abuse in the TCPA. Some of those, the testimony and the discussion was very eye-opening, or should have been, to folks who haven't been watching this. So I do think Congress should modernize the law, even if the court sort of cleans it up or ratifies it, right? That's a lot of pressure to be putting on the court, and they may not be as crystal clear as one might hope. So personally, I think yes, resounding role for Congress to get in there and stop this particular misuse of the TCPA by getting rid of the statutory penalty. And this is my wish list. ILR has its own wish list, but the mandatory statutory penalty should go. They should clarify the definition so that we're not constantly litigating whether a new technology is ATDS. And then I think they really need to look at some meaningful safe harbors and defenses from these lawsuits. As Mark said very well, there are companies that are out there, not just big companies, like little companies, who are trying to get this right and have to be in fear of massive liability or go and seek a waiver from the FCC. That's just not a tenable situation. So there should be a safe harbor that protects companies who put in place reasonable compliance programs, right? Checking your lists of numbers. But right now it's like a giant game of gotcha for the smallest of foot faults, calling a reassigned number. And that's just not tenable or fair to the business community. So that's my spiel on yes, Congress should modernize the law.
Mark, what about the FCC, Mark?
Well, I think whether the FCC or any other part of the administration, I expect you'll continue to see a more holistic approach to both protecting consumers and sorting through how the legal frameworks, the approaches for communications, for robocalls. As we saw in the last administration, it's not solely a TCPA matter anymore. It touches on other issues that affect the calling ecosystem, when calls and text can go through, where the TCPA intersects with other types of network side issues. I think you also see robocalls starting to have a broader discussion over at the FTC and not just the FCC with TCPA. So there's a lot of pieces, right? And I think if you step back, I'd expect this administration to be active at looking at all of the different ways that unless and until Congress changes the law, and unless and until the Supreme Court weighs in with a particular interpretation, that this administration can look to see what it can do on behalf of consumers. Now, my hope is that in that effort, they will do something that I think the last Democratic administration did not do. And I think that is to avoid being reflexive with these issues. Don't just reflexively assume that there are, certain harms happening or that higher call volumes automatically mean something's gone wrong. And instead to really dig in on the details. It was the prior administration's FCC, the Obama administration's FCC, that tried to turn every consumer into a TCPA violator in waiting, right? To decide that a cell phone was an auto dialer. So every call and text that every consumer was making could have been subject to the TCPA. I'm hopeful that we get a more thoughtful approach this time around, and one that frankly could last challenged in court.
And Matt, reading tea leaves is always hard. And, the FCC leadership is not formally in place. Acting Chairwoman Rosenworcel, however, has been there for a while. And I think, I went back and skimmed her dissent and her opinion and partial dissent in the 2015 proceeding at the agency that looked at auto dialer. And she did have a chunk in there that discussed the litigation faced by schools that were trying to communicate with their populations and how that was worrisome to her. And so I think there is room for a thoughtful approach to these issues that would recognize the need to protect consumers and the need to rein in some of these litigation abuses and bring some clarity here. So I think we shall see what's going to happen, but I'm cautiously optimistic that we'll see some thoughtful policymaking going forward. These issues are always challenging, though, and so we shall see.
There's a really good recent example out of the last administration. So in December, the FCC issued a TCPA decision that limited the number of calls, and these are non-marketing calls, that companies can make to residential landlines. Okay, so to be clear, generally speaking, people that have a residential landline in 2021 don't have other meaningful forms of communication. And so you're thinking about people that may be in rural areas where there's less cell coverage or less robust wireless offerings. You might also see consumers that are maybe on the older demographic side of things that are more happy to sort of just have the landline piece. And so what you've seen is the last FCC decided to limit the number of vaccine reminders, delivery notifications, supply notices, all these things that have to be made through pre-recorded calls, right? Because they're happening in real time to lots of people. And it's a really tough situation now that we're in the middle of a pandemic and some of the consumers most in need can't get the information that they really need. So I'm hopeful that the new FCC will do something to fix that.
Well, Mark, I think you get the last word, and we've reached our end of our allotted time for this, but wanted to thank you both for being along with us today. And we'll see what transpires with the court, as well as potential legislative and administrative reforms on the Telephone Consumer Protection Act going forward. But again, thank you both for being with us today, and we'll be talking again soon. Thanks all.
Thank you.
Thank you.